Good evening. This is Laws 11057, Introduction to Law. It's week 6, and tonight we're dealing with half the prescribed reading, that is chapter 12, being committed to justice. And next week we're going to have an extra session where we'll deal with the second part of week 6 reading, which deals with being ethical. And I've got something special for you, which I'll download. So tonight, speaking of things special, our special guest who has volunteered, and thank you, Peter, for volunteering, is Peter Ferry. He's going to show us something about how to use Barnet and the advantages to you in using Barnet. Can I hand it over to you now, Peter?
Yes, thank you very much for that, John. Okay, so as a result of discussion a couple of weeks ago as to this new tool of Barnet Jade, or Jade Barnet, depending which one you want to call it, I started using Jade Barnet and also threw up a video on the UCRU site, and John just asked me if I could deliver a similar presentation to the whole class. So that's sort of where we are at the moment. So I'll just start my screen sharing up and then I'll get that set up for you. Let me see. Share screen only. So can I just get a quick thumbs up to make sure you can still hear me?
Yeah.
Okay, thanks. So Jade Barnet probably helps spoken up the UCRU site. So he get out of the way. Okay, so I'm actually already logged into Jade Barnet and I'm on my Jade screen. So I'm actually just going to jump back to the home page. Now, when you first log into Jade Barnet, once you've created your account, this is what it looks like. Now you've got the browser, citation, all these other buttons here. But usually the most important thing is you just want this search bar at the top. Now that lets you search through all the cases and all the legislation that Jade has on their system. And actually I'll just do a quick one here. Like this is a case that this is one of the parties from a case that I used for another assignment. And so I thought I'd actually use this as the example. So I'll just do a search for Klein. And the case that I wanted, luckily enough, actually comes up first up, which was this Klein versus the official secretary for the Governor General. Now, the only reason I wanted to show you this is what the search results look like if you put in a case. And as you can see, it straight away gives you the title of the case, citation for it, and a little bit of what would be on just the cover page, that initial matter. But if I actually go into this particular case, I've actually got the entire case here, just as with any database site. You can see I can just scroll through and see the whole thing if I want. But the interesting bits that Jade put in are actually right at the top. And just on the right here, it gives you the citations. It actually tells you, if you didn't know already, that this particular case was on appeal from, well, in this case it's the Administrative Affairs Tribunal of Australia, and I could actually click on that and see what that particular case was. I actually know that, as far as Jade knows, that there were 7 citations to this particular decision, that it has cited 20 cases in this judgment. 10 pieces of statutory material legislation were considered. Not sure what that is. That could be 2 sections of this that were cited further up. Tells you that the most recent citation for this case was this one here. And I also find these handy because particularly the citation report, because most of this stuff will just jump you to the bottom, which is the citation report. And it gives you the litigation history, so you can actually track this particular case, as long as Jade has all the information, from the very first instance all the way through, so you can actually see the entire history. You can also again see all the other cases that cite it, and I think when you click on the numbers here, that's when it actually jumps to a particular, to the actual part of that case where the citation was. So like here it just mentions it's in this part of the other case. So it's a very handy way if you want to find out where this case is mentioned somewhere else and how it's been done. Then we look at the cases that cite it, and it behaves exactly the same way. And then it tells us quite clearly what legislation was actually cited by this decision. And I do seem to remember down the side, and I think it's linked to that thing where it says parts of this case that are cited, and they'll just pop out on the side and just say like, no, paragraph number 32 has been cited by these 3 cases. So you don't actually have to jump out to other cases all the time. You can actually see it. It's the one you're looking at. Now, the other little bit, or the other main thing with Jade is the alerts, and that was actually what we were talking about a couple of weeks ago. Now, to make an alert, which will tell you if new cases, what the outcome of cases are when the new cases that have been settled. And it is quite handy because I've got mine set to show every 3 to 4 days, and I get like a digest email that says, for in my case, the Supreme Court and the High Court, what new cases have been settled, and I can see what's going on in the world of legislation. And I'm just going to the alerts and pop them up. I'll just go My Jade, legal. And can everyone just check the mic? Oh no, just switched off, I think. We've got a live mic somewhere. When we go into My Jade and alerts.
Sorry, Pete, it might be Julie. We're having a bit of troubles with Julie tonight. Julie, are you using your mic? Thank you. Sorry to interrupt.
No, you're right. Okay, so we just go to My Jade, we go to alerts, and you can see here, as I mentioned, I've got 2 alerts set up. This one tells me I'm looking at the courts, and it's the High Court of Australia and the Queensland Supreme Court. I get an email roughly every 4 days if there's cases that have completed. And I also set up a daily one that's supposed to send twice daily, and it's for just the Supreme Court in Queensland. But if I want to create a new one, I'll just click on New Alert. If there's particular keywords I want to look for in a case, I'll type them in here. If there's a particular topic, like say taxation, let's see if this works. I could tell it that I'm only interested in taxation and revenue cases. And then I say what court legislation or other. So again, well, let's say I'm only interested in federal. So I'll just start typing in federal. And let's do the Federal Court of Australia. And let's do that one every week. So now I should get an email once a week if any new taxation or revenue cases are settled for Federal Court of Australia. That's the idea of that one. Now, this is where the catch is. If the search works or not is a different thing, because the reason I set this 3rd one here up is because I noticed that Jade seems to be sometimes a bit slow in when it sends updates. I do not get 2 emails a day, and it definitely is not between at 7 AM or 7 PM. Usually it's about 9 o'clock. But for the most part, I do get more frequent emails when I use the daily option. And obviously, if I don't want a case anymore, I can just tick it off and delete it, and it say that it's done. And I can always tick one off and edit it if I want to make any changes. And the only other little catch I noticed with this section here is sometimes if you refresh the screen, it actually reverts to the state it was in previously. Like there's a good chance if I just hit the refresh button in my browser now, that taxation report will search will actually turn back up again. Like in this case, it's calling me a liar and it hasn't actually come back. But I have noticed in some cases it does come back and you just have to wait like half an hour and it does eventually refresh and update and get everything settled. So unless there's any particular questions, I think that's about it from me, unless John wanted me to talk about something particular.
That's an excellent presentation, Peter. Really appreciative. I've learned something from that. I'm going to re-watch this video and study once again what you've just said. Now, Catherine says you're very clear and you've made it easy to follow. So thanks, Catherine, for that feedback. I'm very, very happy with that as well. Are there any specific questions? Michael?
Yes, I'm actually just looking myself too, because I didn't...
I'll leave it with you.
Okay, so someone asked me, does it bring up any journal articles? Let's actually have a quick look. I'll actually just share my screen again. And I'll do that Klein case again, because I know there are 2 journal articles that exist for that one. But I do not actually remember that Jade has a journal search, has a legislation search and a case search as far as I know. I was going to say, it'll say it down the bottom. It doesn't look like there's anything. So I would have to, my initial response to that is going to be it doesn't have any journal searching. It's strictly a legislation and a case search only. I think that's the only question. Or yours, John?
Your question from Julie. Julie, are you ready?
We can't hear you, Julie. You'll need to turn your mic on.
Sorry, Julie, we're having some technical issues there. We can't hear you. Sorry.
Can you put your message up on chat for us, Julie? Then we can respond. We'll probably carry on, John.
While we're waiting for Julie, thank you very much.
Oh,
really appreciate it, Peter. That's great. Oh, there's a question that's come up now. I'll leave that with you, Peter.
Yep. Okay, so is there a way when you call up case law in researching that brings up paragraph numbering for footnote purposes? When you call up case law in research that brings up paragraph numbering for footnote purposes, what would you make of that one? Okay, is there a way when you call up case law in researching that brings up the paragraph numbering? So I'm thinking when you look at the case, like in this particular one I keep referring to, you've got your paragraph numbering on the side all the time. So you're thinking like so and so at paragraph. So you'll okay. I think I know roughly what you mean. You mean the same as in some of the cases where they actually say that in another decision. Oh, yes. Okay. I've noticed some of the older cases, like someone versus the Commissioner for Tax. I can't remember the name. Well, probably it's this one, isn't it? Oh, I'm blanking out. No. There's another one, Trevisan versus Commissioner for Tax, and then for another case, and that was a old Federal Court Reserve articles from '91, and that didn't actually have paragraph numbering in it at all. So I think if the paragraph numbering doesn't exist, it's because the drafting style has changed over time. So I think at that point, when you do your point referencing, you just use a page number if you've got a page number. If you've got a paragraph number, you use a paragraph number, otherwise use a page number. John seems to say I'm right because he's nodding.
Absolutely. No, I agree with that, Peter. Sometimes it might be a case of both using a page number and then saying at a certain paragraph number. All right, so Julie's nodding. I think that's answered a question. Peter, thank you very much. That was an excellent presentation and we're all very appreciative. So I'm looking forward to seeing who the next volunteer will be. So like Catherine, you've done an excellent job and we're very grateful. So thank you very much. Look, if I could now invite you to consider the issues raised in Chapter 12, which is half of the reading for week 6. This is all about being committed to justice. And can I say from the outset that if you want to take on cases, it won't take you very long before you can find them. If you ask a few questions of practically everyone, it wouldn't take long before you could raise with them the possibility of litigating something. Almost everyone is involved in an issue which to them is of varying importance. So if you want to become heavily involved in a volunteer situation or taking on a cause, you can very easily become extremely busy, and that's at any level. In terms of being committed to justice, there are a number of areas of law which come to mind, at least to my mind, where you could make an impact in a real way. Now, I'm going to ask for some quick fire responses here. Perhaps you can do it verbally or you can do it through the chat facility if you like, and I'll read them out. But where do you believe, as a practicing lawyer, you would be in a position to make a difference? Where is being committed to justice going to assist others by your expertise and your abilities? All right, so where are we looking at? If I could make a start, criminal law. Someone is doing some, is caught at a police station and you can provide them through your assistance in criminal law. Doing pro bono work. Thank you very much, Julie. Are there any others coming through? Legal aid, Vicky, yes, and legal aid is not always easy to get. Duty lawyer on a Saturday mornings, thanks, Julie. There must be some other ways. Community centres, thank you, Peter. These are ways that you can make a difference. Thank you, Catherine, Community Legal Centre as well. What about human rights law? We all know the difficulties that people go through at an international and a national level. So human rights law is another different issue. Family law, says Josh, pulling kids out of an abusive home. Thank you very much. That's a way that as a practicing lawyer, you can really make a difference. Come on, there are plenty others. Let's put out our thinking caps. What about immigration law? Does anyone have any issues with immigration law? Do you think you could make a difference in that situation? There has been some talk about child protection in the family law context, but there's also child protection in the context of dealing with the Department of Community Services. Asylum seeker law, yes, thank you very much. What about environmental law? We've seen plenty of movies, haven't we, where lawyers have made a real difference in terms of assisting people in dealing with the environment. Animal rights, thank you, Peter. I was surprised it took so long for that to come through. Maria said it almost at exactly the same time as you. What about dealing with people with mental health issues? Coming to the aid of people that are disadvantaged generally, mental health, etc. Any client's claim where an injustice has occurred, says Catherine. Thank you very much. And again, plenty of movies that highlight that. Dealing with adults with impaired capacity through guardianship and administration might be another way to go. So it doesn't take long at all before we can start to think about ways in which we can make a difference if we are truly committed to justice. And that's the theme of tonight's talk. How can we go about making a difference? And start thinking about that now. Don't think of yourself necessarily as a first-year lawyer who is powerless to assist. You can make a difference now. Have any of you thought about writing articles for magazines, for the newspapers, lobbying, joining community legal centres, asking if you can volunteer at a law firm to assist people in a real-life situation? Maybe someone would like to have a ghost researcher to assist in a worthy case. So there's a whole lot of things that you can do right now which might be of some assistance. Maybe anti-discrimination is another area that you can think of. All right, enough of that. Now let's talk about having some procedural justice. You've all read the material, I know that, but what do you think are the most important things in terms of the procedures which must be followed or should be followed in a hearing which will enable justice to be undertaken properly? Are there any thoughts? And again, I'm giving you a bit of homework tonight. Peter's done his share, so we don't need much from Peter, but it's very, very welcome. But I'm asking all of you to contribute. In a hearing situation, in a trial, what are the most important things that come to mind in terms of fairness and justice? What about obtaining a fair hearing as a general rule? If someone is being called into court as a defendant or being prosecuted in a criminal matter, they want a fair hearing. So what are the ways that that can be done? How can someone get a fair hearing? Let's say in a criminal law context, what are some of the important rules in criminal law to ensure that under our criminal justice system, people do get a fair hearing? Jury, thank you, Catherine. That's a very good way. It doesn't apply always. Appealing an injustice, the evidence.
Standard of proof.
Standard of proof. Was that you, Josh? Thank you very much. No, Michael, sorry. So standard of proof, and how does that differ between criminal and civil, Michael?
So was it criminal is beyond reasonable doubt.
Very good.
And civil is what's civil? Just the probabilities.
Exactly. Very good. Thank you very much. So understanding that is all important. When we talk about the standard of proof, we also talk about the onus of proof, which is who has the burden of proving something. Well, when it comes to criminal matters, that's the Crown, that's the police, if you like, have the task of proving, which means that the respondent, defendant, the accused can remain mute, essentially say nothing and just simply allow the police to prove the case if they can. And Michael's right in terms of the standard of proof that we've talked about. There are some exceptions to the right to refuse to answer questions which might incriminate, which is the case in criminal law proceedings generally. And some of those exceptions are in ASIO investigations and in the Crime and Corruption Commission. So if you're acting for someone who has been called to appear before the Crime and Corruption Commission, then the first thing you should let them know is that under the legislation, their right to silence is removed, but it's only in that very limited jurisdiction. That doesn't apply when dealing with police generally, and it doesn't apply in dealing with court proceedings, only in ASIO or the Crime and Corruption Commission. All right, any questions about that so far in terms of procedural justice? If not, we'll move on. Retributive justice versus restorative justice. So retributive justice is all about how best to punish a person. It's often thought of in the context of an eye for an eye. And it's what generally is a vote winner in terms of politicians talking about obtaining justice. Probably less emphasis is given to what is, in my view, the more important type of justice, and that is restorative justice, which is all about restoring someone and healing the victim or reintegrating the offender into the community. So that's the difference, in a sense, between retributive and restorative in the criminal law sphere. If you have any questions or comments, please feel free to dive in and make comment. So I'm moving fairly quickly through tonight's session. Access to justice, we've talked about legal aid funding. What about the lawyer-free jurisdictions that we're seeing more often now? How do you feel about that? Does that help or hinder participants in terms of obtaining justice? So in the Queensland Civil and Administrative Tribunal, for example, for the most part, it's lawyer-free jurisdiction. There are some exceptions to that. Do you think that that helps people, or does it make it more difficult for people? There's not necessarily a right or wrong answer, but these are issues that need to be considered. And remember, of course, all of these things are examinable. So we want you to consider these in a critical sense so that you've created your own thoughts and your own ideas in relation to them. Let's talk about discrimination, disadvantage and injustice. Now, can you think of some ways in which our legal system does work to disadvantage a number of people or create injustices simply because of the way in which the system operates? Now, are there any thoughts that you can add these onto the chat facility? We're talking about discrimination, disadvantage, injustice. Are there groups of people that are, because of our current legal system, at a disadvantage? If so, let's see, fire away. I know it's a tough one, it's a bit cryptic, this question. What if I start by saying the cost associated with law? Those who can't afford it, Maria, thank you very much, you hit it spot on. Got a problem with the mic, I think, somewhere, by the way. Are there any others? So those who can't afford it, yeah, thanks, Michael.
I'd say immigrants, and actually Steve said similar to me, is ESL or English as a second language.
Yes, so immigrants, people that have English as a second language, absolutely. Are there other people that are disadvantaged through their own circumstances, and those circumstances are not perhaps appropriately addressed through our legal justice system? So we've talked about cost. Yep, thank you.
Yeah, Indigenous Australians.
Yep, thank you very much, Michael. Well, that was Michael, wasn't it?
Yeah.
Thank you. Indigenous Australians. Are there any others? Can I just pose this question to you? Do you think that it's easier as a police officer to involve him or herself in prosecution of what we might call low-end street offences as opposed to high-end white-collar crime? And if so, why? And if that is the case, does that disadvantage one group of citizens more so than others? While you're thinking about that, Julie says self-litigants, yes. And Peter, thank you, Maria. Thank you, Michael. Yep. So is it the case that low-end offences tend to be prosecuted more readily than high-end white-collar crime? Does that matter? Is it not true?
No, I think it's true.
Okay, so we're getting a yes from Michael. Vicky says yes as well. Someone else say homeless. Yep. Thank you, Peter. White-collar criminals had deep pockets. That is an issue. And of course, it's harder to prove. There are issues associated with resources. Depends on the extent of the crime and how hard it is to prove. Thanks, Josh. I agree with that comment. So the reason I'm saying this is not necessarily because there's an answer, but because I want you to start thinking about these issues in the context of tonight's seminar, which is all about being committed to justice. Think about justice in a wide sense. Senior counsels, good lawyers, can be afforded by people wearing the white collar, so to speak, more readily than those people that are in that disadvantaged set that we talked about. What about mandatory sentencing? Do you believe that the imposition of mandatory sentencing through legislation does disadvantage one group more than another? If you've read your book, there's some good commentary in this, and that's a hint, and I'd like you to dwell upon that. So does mandatory sentencing adversely affect one group more than another? Well, let's say, for example, that a mandatory sentence requires a period of disqualification for a period of time. Arguably, that penalty will be of greater impact on someone who is in a low socioeconomic situation, perhaps with financial commitments, perhaps with children, perhaps a sole parent in those circumstances, than it might be for a person who can afford a driver, and it won't really have an impact. So sometimes mandatory sentencing can have a greater impact, adverse impact, on some members of the society as opposed to others. So lower income earners, says Vicky, it does impair equity. Thank you, Peter. And you can see my point, and I'm really just asking you to think about these issues in a very critical way. Do some extra reading. Think about how you might answer a question like this if posed in an examination. All right, I said it would be a quick session tonight, and that's partly because of my circumstances, I'm sorry. So the last thing I really want to talk about is alternative dispute resolution and ways in which you can use alternative dispute resolution techniques in the context of delivering justice. We've talked about the cost of litigation. That can be prohibitive in certain circumstances. So maybe one way to create justice where it didn't otherwise exist is to encourage parties to undertake different ways of resolving issues. So what are, if we use that term alternative dispute resolution, what are some of the terms that come to mind as a way of deciding something in an alternative manner that is an alternative to pure court litigation? Now, conciliation, mediation, thank you. Josh says, yes, I agree with both those. Are there any others apart from mediation and conciliation? And if I could just say negotiation, thank you. Thank you, Catherine, thank you, Peter. And at this stage, I'll give a plug for Laws 12062, which is Alternative Dispute Resolution, which I had the pleasure of taking this year. I hope to get it again. Arbitration, yes, these are all great answers. Thank you very much. Negotiation, arbitration, absolutely. I'll just go through the list that I've written down. Negotiation, partnering, dispute advisors, dispute review boards, facilitation, conciliation, mediation, which is the most popular and probably the best, collaborative law, expert appraisal, expert determination, early neutral evaluation, mini trials, referencing, adjudication, and finally, as was identified, arbitration. Now, we have lots of different terms for different ways of resolving disputes, and it may be that if you can pique an interest in those different terms in the whole field of ADR, you may come up with a way of creating justice for a client that didn't otherwise exist. All right, and just finally, you're aware I'm a member of QCAT, and in that QCAT jurisdiction, we have a great emphasis on alternative dispute resolution, mostly through conciliations, which we call compulsory conferences, and also mediations in the pure form. We also have a special thing, and senior member Peter Stilgo was the champion of this. They're called hybrid hearings, and they're, as far as I'm aware, a peculiar beast to QCAT. A hybrid hearing is essentially where there is a hearing of the matter, the member makes a decision in relation to the matter, but doesn't announce the decision, but simply writes the decision on a piece of paper which is then sealed. Following that, the mediator gives the parties who've now heard all the evidence and are aware that if they don't come up with their own decision, a decision will be imposed upon them. It gives those parties a last-ditch opportunity to try and sort it out themselves, and the member who heard the matter morphs into the role of mediator in a very basic, non-inventionist way to help the parties come up with their own resolution. If the parties can't, in that mediation session, which immediately follows the hearing, then the member will discontinue the mediation discussions, go back to his or her bench, position on the bench, unseal the envelope, and announce the decision, which then becomes binding on the parties. But the whole idea of that is that sometimes after the parties have heard all the evidence, they're in a position where they can come up with their own agreement. And generally speaking, at least in the QCAP jurisdiction, people coming up with their own decision, as opposed to having one imposed upon them, is seen as being of benefit. All right, I know I've been through a lot of things quite quickly. I appreciate we haven't done ethics. We'll do that next week. So I'm about to sign off, but before I do, are there any questions? I can't see anything on the chat facility. I'll just scan. Does anyone look like they want to ask any questions or make any comments? Here's your chance to do it. All right. I'll end the recording at this stage. And for those that are viewing through Zoom sessions online, we'll see you next week. Thank you.